Well, let's hear now from Joseph Kotrie-Monson, a criminal lawyer who joins us from Manchester. Thank you so much, Joseph, for joining us. I know that you worked on the alleged Facebook hacking. Sorry, no, my auto cue is moving on. But I know that you've also worked alongside some of Donald Trump's lawyers. If you could just give me your reaction to this verdict.
Yes, well, good evening. My awareness of the Trump machine, as you're correct in saying, goes back to that Cambridge Analytica US election fraud allegation of around the same time, the run up to the 2016 election. And the rule we stuck to in that case, my firm was representing the chief of operations turned whistleblower. And that was crucial. The rule that we stuck to in achieving that was that in these types of cases, no matter what the temptation, you play the game according to the evidence, not according to the politics. Of course, that's not how Trump does it. It's not how he's done it in his pre-trial conduct and during the trial outside the courtroom, and even engaging, I think, properly with the proceedings. He didn't give evidence in his own behalf. All of those times that he was saying, and I will speak in court, I will answer questions. Of course, he never likes to get close to a situation where his answers can find him out.
Yeah, he certainly spoke at the beginning in the mornings, for about 10 minutes to the press, and then at the end of the day, but never in court. And we was just speaking to Michael Wolff there, the author, who said, you wouldn't want to be Trump's lawyers right now because they really would be getting it in the neck.
Yeah, well, there's a lot to do, isn't there? Because he's now a presidential candidate, a former president of the United States of America, leader of the free world, and he is now a convicted felon. And while prison is unlikely, nobody can or has ruled out the possibility. These charges are low-level felonies, but felonies nonetheless, and aggravated substantially because they go directly to the integrity of the 2016 presidential election. So for their type, they are immensely serious. And while he will be furiously, as he's given us some clues, some breadcrumbs in some of his media statements about some of the things he's unhappy about the fact that he wasn't allowed to call loads of expert evidence as to election law for the jury, and also extra evidence, bad character evidence, we call it, relating to Michael Cohen's credibility and even a venue change. He'll be preparing all that. But the reality is the judge was right in law on those things, especially anything that relates to the findings of a jury, because in the US, unlike in the UK, they have a very strict jury selection process that favors the defense and prevents prejudice. Ironically, that's precisely the reason that a defendant can get away with making these prejudicial statements during a trial. It's because by both sides have already had an opportunity to check and make sure to vet effectively jurors to make sure that they've got the best possible chance. I think this is a safe verdict, and I don't think he's going to have much luck on appeal.
And I guess at the end of the day, the prosecution delivered, Michael Cohen delivered.
He did, and he wasn't an easy witness for the prosecution to rely on, was he? In fact, looking at the three of them, Michael Cohen, he's a self-confessed liar. His evidence is essentially to that effect. He's somebody who lied for and on behalf of Donald Trump. He's somebody who also had to concede in cross-examination that he had stolen from the Trump organization. The prosecution were very clever at not overplaying their hand in this regard. They said you should regard him as a guide through the evidence, a tour guide through the evidence, not necessarily somebody who tells you the truth on everything. And that's good because, of course, what they had was a broad picture. They had Stormy Daniels as well, also not the best witness in some respects, because some might view, at least morally, the fact that she took the payments in the first place as a kind of form of bribery or blackmail. And of course, the National Enquirer head, Pecker, confessing to being part of a catch and kill conspiracy to influence, presumably with the effect of influencing people's opinions in advance of the 2016 election, also not attractive. But that, plus the paper trail, a chorus of voices, it was a messy case. Prosecution recognized it and still managed to get it over the line. I think really that speaks to their judgment, but also the quality of the evidence and the fact that the jury were able to hear everything and coming back with a quick verdict like that, never good for the defense, a quick verdict in a complex case. It really shows that they were convinced.
Yeah, as you say, a very quick verdict. Thank you so much, Joseph Kotrie-Monson, a criminal lawyer, joining us there from Manchester in the UK and giving us a sense of how things will evolve and develop as we head towards the November election. Well, let's go to Washington now and speak to our correspondent, Mark Stone.